Well, this morning I'm joined with Kate Avery, who's a good friend and colleague. And Kate and I go back a long way. In fact, I think I recall sitting close to you while we were reading cases in the UQ Law Library all those years ago.
Where we always were.
Yeah, indeed. Now, we're talking about ethics in negotiation, and we had a recent discussion where we thought this is underdone as a topic and it's important that we delve into it. And we've both been very much personal injury lawyers over long careers. But what I want to talk to you first is about your perspective from both a plaintiff and defendant lens. I'm in both rooms now as a mediator, as you know, but tell me, in terms of your professional story, who is Kate Avery?
As you say, I'm a personal injuries solicitor. I've pretty much always worked in personal injuries litigation. People often ask me why I chose it. It wasn't because I desperately loved torts at uni. It actually chose me. I remember spending my first interview being asked about my background in Beaudesert and the meatworks there, because as we know, a lot of work cover claims arise out of the meatworks. And I acted for plaintiffs in the first part of my career. I took what I like to call a sabbatical of 9 years acting for defendants. And then Renee and I started Kare Lawyers in 2016, and we act for plaintiffs in all areas of personal injuries litigation.
Excellent. And how big is your team, Kate, at Kare Lawyers?
Yes. Well, let's see. We have 4 solicitors and 2 support staff and part-time accounts manager and part-time IT.
And you're up on the terrace. I've seen you up there.
We are. Yes, that's right.
And you do a broad spectrum of personal injury work.
Yes, everything. Yeah, everything.
Similarly, I think personal injuries found me. One of the things that I really like about it is that it's enough of an intellectual stimulation, but it's enough about people's stories.
Yes.
And I've always liked that aspect. I started actually for a couple of years doing criminal work, which gave me great exposure to the court process, but I've really enjoyed doing that personal injuries work since. Now, we're going to take a deep dive today into ethics, because we both had a conversation which we said is totally underdone. And the ethical rules, of course, all flowed from the duty to a court, which was well considered and developed over time. But we're in an area of law in which so many cases don't go to court, the vast, vast majority.
Deliberately, yes.
Yeah, that's right. And so I think there's a lot that we need to drill down on and understand about ethics in the negotiation space. And I know when we spoke recently, you had the same view.
Yes.
That it's underdone. And I certainly recall, in various guises at the QLS and doing ethics more broadly, but nothing particularly bespoke often to negotiations or specific to negotiation or mediation.
No, that's right. And I think unlike the ethical obligations when you're before the court, it can be very conflicting pressures, ethical pressures on you as a practitioner. And when you're a junior in particular, you're under enormous pressure to make that decision very quickly about where is my responsibility here?
Yeah.
Before the court, it's a little bit more binary, because obviously first obligation is to the court. Yeah. It's not quite so straightforward a lot of the time in negotiations.
No, and I want to draw on a few scenarios because it can be quite nuanced. I mean, let's sort of paint the bigger picture to start with. I mean, obviously the ethical considerations need to be first seen in the lens of your, if you like, primary duty to your client to advance their case on both sides of the record, of course, and to do that diligently and robustly at times. But of course, it has to marry up with an obligation to your opponent as well. And it's those obligations when they conflict that we see some cases arising, when those, if you like, or those duties, I should say, when they conflict. The cases, and there's not a heap of case law out there, but the cases that we have seen, broadly speaking, involve that conflict.
Yes.
And I think part of the fallacy, if I can call it that exists in this space is something along these lines, that we as practitioners know that when you go to court it gets serious. We've got an obligation to court, we're, to the administration of justice. It's all reasonably well understood. So court is where it gets serious, but when you're negotiating, it's a bit of gamesmanship, a bit of bluff and bluster doesn't hurt, all's fair in love and war, we're doing battle here. And so I think at times there's been less regard, as there ought to be, to ethical obligations. And of course, as you and I both know as practitioners, that is in fact a fallacy, because there is an interdependence of information that you're entitled to rely on in the negotiations context. So what's your sense of that, Kate?
I think where the complexity arises quite often is, there's two things really. There's the complexity that comes from exactly what you've just described, that complex interaction of competing duties. But there's also the issue that you're having to make that decision while there are often people yelling at you. Yeah. Emotions are running high. You've got a client that's saying, why on earth would you say that?
Yeah.
That's against my best interests.
Yeah.
Well, yes, it is, but I was asked a direct question by my opponent and I can't be misleading or deceptive. The converse is also true. Sometimes you have the other side yelling at you, well, you have to tell me this. Well, maybe I don't.
Maybe I don't.
The difficulty with learning all of this in an abstract environment like university or at a conference and that sort of thing is that when you're in that environment, it seems pretty straightforward. I know when I studied ethics at uni, I was just thinking, I've got a strong moral compass. Yeah. I know we can't be misleading and deceptive. I won't be. But when you're in a very tense environment with emotions running high, and particularly as a junior where you don't necessarily have the confidence that you're correct and that what you're doing is the right thing, that's an enormous amount of pressure. And I think as we've seen, sometimes the best thing for you to do is to go and ask somebody else, somebody who's not under the pump, but that person isn't under the pump. They're not seeing all of the nuances of it and they might make the wrong call as well.
That's right. And we've seen that in one of the cases actually.
We have, yes, which is why I am very sympathetic for people who do get it wrong because I think it's all very well to review the circumstances after the event and say, well, that was clearly misleading. But there's a tendency to underestimate how much pressure somebody's on in a particular environment.
And the real obligation you take very seriously to advance your client's
Absolutely,
case.
Yes.
And that's got to be seen in that lens. One of the things that you spoke about responding to your opponent and not being false and misleading and the line between that and, of course, puffery, and we might touch on some of that. But one of the things I've noticed as a mediator and as an advocate, and it certainly was how I changed my practice, particularly in the last 10 years as a solicitor, was I used the conference process as much as a process of discovery, as much as a process of articulating my client's position. So you'll find now lots more questions.
Yes.
People are approaching conferences and mediations with asking, which is a good thing in terms of...
Yes, it definitely is, yeah.
But it does bring with it, obviously, those duties become highlighted, don't they?
Yeah. I'm thinking in particular of when a practitioner on the other side says, do you really think this would succeed at trial? Do you really believe that? And really, we're told that we're supposed to be honest about that. And most of us have run a case where we've thought, this can't go to court, this can't go to court. Or we have a client who said, whatever happens, I'm not going to court. We'll take whatever they give us, but we're not going to court. What is our responsibility then? Because for every client that I've had tell me that, they've changed their mind when faced with the reality of you have a claim that has prospects and risks.
Yeah.
Nothing is being offered. Are you prepared to run it to trial? So I don't feel like I can be anything other than misleading in those circumstances, because if someone says, is your client really prepared to run this risk?
Yeah.
Well, if I say no because they've told me no, I don't know that that's real either, because I haven't put them in that situation yet where there hasn't been an offer made. Now your options are abandon the claim or proceed to trial. Most people will proceed to trial.
That's a really good point you make, and and I've seen that play out as a mediator. You gain the impression reasonably quickly whether someone has an appetite, what their risk appetite is, as much as the legal prospects. You really are sounding out risk appetite on both sides of the ledger. Actually,
interestingly, there has been some academic papers come out of the US of all places where they've specifically pointed out that ethically we shouldn't be advancing cases or we shouldn't be overstating the prospects of a case or overstating the value of a claim or
our client's appetite to run a claim.
Or their appetite to run it or the prospects of success. I did figure out very early on you can't misrepresent the bottom line.
No.
No, my client's not prepared to do that. I used to think that would be acceptable because that's something that happens just generally within the commercial sector.
Yeah.
But we can't do that in litigation, so that's fairly straightforward. But when you're talking about misrepresenting the amount of damages that could be recovered at trial, Well, we all make ambit claims, and the reality is that sometimes we make an ambit claim and the parts that we thought were not as strong as others, the court disagrees, and it's the other way around. It can be really complicated, but added to that, as I say, the pressure of the negotiation environment.
Absolutely. I've also reflected on what constitutes a material misrepresentation in this space and what does that mean and how can we give practical guidance to junior lawyers coming up. So let's talk about what is a material misrepresentation or material fact that you've got to be very careful about, and what do the cases tell us about where it's all gone wrong, if I can say that?
Yeah. Look, as you say, there's not a lot of case law on it. But certainly the solicitor's conduct rules make it clear that we can't go beyond reasonable advocacy for our client. One that is clear, as I mentioned before, is we can't misrepresent the bottom line.
Yeah.
Now, acting for defendants, I did actually have non-legally qualified defendants give me specific instructions to say that an offer was the final offer when they had also told me that it wasn't. Now, that's really hard too, because particularly for junior solicitors to stand up to a client who's potentially got a lot of sway, got a lot of power over you and the firm that you are employed by, and to say, I can't do that, that is unethical, but we have to do it. We have to say, no, that would be lying. That is a material misrepresentation, because if I go to the other side and say that is our final position when it's not, there's no question about that. That's black and white.
And when you get more senior, you realise your credibility matters. And
yes.
And so the way I rephrase that in mediations is very careful to say that is the limit of the instructions.
If it is the limit of because if it's not, if the position is, we'll go to X amount, but tell them that we won't.
Or you might even say something more coded, which is this is the present limit of instructions, which might be necessary, because there might well be, that might genuinely be, of course, the case. But that's right.
True.
I think that's, and I don't think that's often understood.
No, I certainly did make that mistake early in my career, because I used to think that, as you say, just mere puffery. But no, we can't say this is all we've got, or my client's not moving from that, when we know that's not true. Yeah. But also we do get a sense from our clients, even our inexperienced litigants, we do get a sense from them as to whether they're throwing their weight around and telling us to do things that they have no intention of doing.
Yes.
And I think we have to interrogate that. Whether that's a material misrepresentation, probably not. I tend to say in those circumstances to my opponent, I'm struggling to see what my client's position is.
Yes.
Because that is the truth.
Yes.
It's quite a common situation. I also think that for practitioners who haven't worked for plaintiffs and defendants, there's not often an appreciation of that. Yeah. There's often this thought that, they form an opinion of the solicitor acting for the plaintiff, not recognising that every plaintiff is different.
That's right, absolutely. And you've got to act on instructions, and people may have very different expectations despite the best advice.
Yeah, absolutely, but also different levels of certainty and the way that they communicate things to us. So we might get a client who says, no, I'm going in with one offer and that's it. And we're working on them through the process to explain, well, that's unlikely to resolve the claim, so how about we go through this process? We can also just get clients who are gung-ho and are going to go to trial no matter how much money we get. And again, we're going to have to manage that. But sometimes we as their representative don't know where they're going. And they just want to know that they're taking charge of the process.
Yeah, and the same in the defendant ledger, as you know. Yeah. You often don't know. No. And often insurers like that. They like to keep
plausible deniability.
Yeah, exactly. You like to keep someone guessing. Yeah. And that, I guess that's a client prerogative, huh?
It absolutely is. They can do that. What we can't do is, if we have been given specific instructions, tell the opponent that we have different instructions.
Yeah, that's exactly right.
So I think that's the very clear division. Where it's more complicated is, as I say, when I've noticed that some very senior solicitors tend to say to me, do you really expect this to win at trial? And that's a difficult question to answer, because we're talking about risk and benefit. Well, this is such a risky case that perhaps I wouldn't be recommending it if the claimant had a laceration or something like that. But because the claimant has a major spinal injury, it's a risk that they're weighing up as against that. I always say it's a bit like the Bolton and Stone rule, isn't it? They're weighing that up and they're saying, okay, this might be a risky claim, but it's a claim with prospects. And so therefore I'm not going to abandon it because there are prospects there.
And there's such high value, and that's a very legitimate position to take. There's one, of course, case in Queensland which we should touch upon. It involves a good person and a colleague, and now a senior professional. And it's just a salient reminder of, I guess, what can go wrong when your primary focus is advocating for clients and not being sufficiently alive to your duty to opponent and how that plays out. So we should talk about that. And we'll talk about, it involves a senior barrister, but also the solicitor, actually, which is often not understood. But let's touch on that case, Kate, the Mullins decision.
Yes. Thank you for introducing it in that delicate way, because I fear that it is thrown around a bit, because it is the seminal case on this point. It's thrown around a bit as a cautionary tale and with a large measure of judgment. And I see the cautionary tale comes from the fact that this was a decision that was being made under pressure. And also, I think it's important for junior practitioners to be aware of the fact that, as you say, the solicitor was involved in that as well.
And the client gave specific instructions, which is really important.
Absolutely.
As well.
So from a solicitor's perspective, certainly when I was a very junior practitioner, I would assume that if the barrister said it's okay, it's okay. I don't know what conversations happened in that environment, but that's just really important to remember, that we can't completely abrogate our responsibilities to counsel.
I agree entirely. Talk me through the facts in brief compass.
Sure. Okay, so this was a case where a personal injuries plaintiff was making a claim for future economic loss. Now, it's inherent in the claim for future economic loss that there is a period of time in which, if not for the injuries, the person would either be working and they're now not working, or that they would be working to a greater capacity. And I understand it was only very shortly before negotiations took place that the legal representatives of this plaintiff became aware of a terminal cancer diagnosis, which was going to shorten the life expectancy of the plaintiff and thus the period of time in which they could claim economic loss. And the decision was made, I understand, after consultation with other practitioners, that there was no obligation on them to disclose this terminal cancer diagnosis. To do so at such short notice would lead to the conference being adjourned. I imagine there would have been some consideration given to the life expectancy potentially needing to reconvene urgently. There were a lot of decisions that were being made very, very quickly.
Yes. I think from memory it was 3 or 4 days before the conference.
It was very, it was very shortly before.
And it was done under the Motor Accident Insurance Act, and there's a provision under that Act which says that you have an obligation to disclose, I think, from memory, within 30 days. Is that?
Yes, that's right. But the question was really more of whether putting forward a schedule of damages which included an allowance for future economic loss that made no deduction for a known diagnosis was a material misrepresentation.
And relying on the medical evidence.
Yes.
Because you're not only presenting the schedule, you're presenting medical evidence and a scenario predicated on.
Yes, which predated this later relevant information. So yes, it was obviously a decision that was made under time pressure and with a range of considerations, and also with a number of practitioners considering it, although probably with differing levels of concentration on the issue and the ethical obligations involved there.
So the conference effectively proceeded and the case settled.
Settled, yes.
And then what happened was it was found out that there was a terminal diagnosis.
Yes. I understand from the Medicare schedule coming through after the settlement. That then meant, of course, that there were ethical complaints made against the practitioners involved and very heavy penalties were imposed. Knowing as we do the practitioners involved, I very firmly believe that decision was made with the best of intentions. But yes, it was quite clearly a material misrepresentation about the prospects of the claimant being able to continue working to normal retirement age.
And was the error premised on this view that it's okay because the conference is so coming up, I don't formally have an obligation to disclose this straight away, so I can just proceed and present my client's best case, and it's kind of up to them to try to find out.
I don't know if that was the thought process.
And remember that, sorry to interrupt you, Kate, but the claimant did instruct.
Yes.
That's really important.
Yes, it is important. That's right. I don't know what the thought process was, but I suspect that with personal injuries claims, we make it all look very mathematical, and we go through this whole process of saying, yes, under the 5% tables, you lose this amount for the remainder of your working life, which used to be 60 to age 65, now 67 and sometimes 70. We make that look very mathematical, but then we descend into negotiations that involve the vicissitudes of life insofar as they relate to everybody, specific vicissitudes insofar as they relate to people with particular predispositions to certain medical conditions. And after you take all of that out, then some would argue that there hasn't been any change to the final amount. But the misrepresentation that ultimately led to the parameters being altered was the problem.
Yes.
So I suspect that the perception would have been, it doesn't matter, they're already going to be discounting all of these things. We know that. We've allowed for that with the client. The client is under pressure to settle because of this diagnosis.
Yeah,
the client will probably take less anyway.
Yep.
Is there going to be any specific loss? And it's worthwhile remembering, particularly for juniors, that that's not the test. It's just you make the disclosure, you work out how to manage it afterwards. But I also do have enormous sympathy for the practitioners involved.
And good people that made mistakes. I mean, one of the things that I've thought about in terms of that case is what should have been done is obviously, well, I'll get your perspective as a plaintiff lawyer, that the plaintiff ought to have been advised that they had an obligation to disclose it, that the conference couldn't proceed. Sadly, there would be need to probably obtain other medical evidence. They'd need to recast the claim, because obviously the misrepresentation was, even though nothing much of any substance was, you've seen the medical evidence, here's the schedule, that in itself, putting that across the table, was materially misleading. Is that a fair... Is that what should have happened? What should have happened?
Yes, well, there should have been disclosure. As to what happened after the disclosure, I suppose that would have been up to negotiation between the parties, because if the claimant's position was, no, I want this conference to proceed no matter what, it might be that the insurer would have been prepared to proceed with the conference.
Potentially.
On the basis that you've got a terminal diagnosis. I guess we don't really know exactly what that means, but we know that it means you're not going to be working through, you were never going to be working through to normal retirement age.
Depends on what the insurer wanted, more level of certainty on that evidence potentially. But, you're right. Potentially insurer might say, proceed. Yeah,
we'll proceed, but then it's going to settle for less accordingly. But with the benefit of hindsight, that's what we definitely know is the first step is disclosure. And then after that, with full disclosure and with all parties knowing all of the information, you then work out how to progress the claim, and whether that is, no, well, we can't have a conference now, we need further evidence, or the claimant is prepared to resolve the claim on the best terms possible on the basis of the limited information currently available.
So knowing that something is wrong in terms of, say, a diagnosis that you don't disclose, it just jumps out of you that you just can't do that as a practitioner.
Well, it does now, doesn't it? Yeah,
absolutely.
Yeah.
Oh, the other lesson, and we touched upon this, is obviously, and it's not as well remembered, that the solicitor was also subject to disciplinary proceedings and the inverted commas defence that you relied on a barrister. So that's an important...
Absolutely.
Just for solicitors to remember that in terms of the salience of their obligations, if I can call it that.
And also for employers of junior solicitors, because sometimes certain firms will use counsel effectively to be the mentors for their junior solicitors. And they're still not going to avoid their own independent ethical obligations to properly supervise that junior solicitor and make sure that they're carrying out their obligations.
Yeah. Can you point, those are the seminal cases I read in Queensland, and they're good reminders. Can we get any other guidance from case law?
There's not a lot, and I suspect that in part that's because we're talking about the ethics that's behind closed doors to a certain extent. A lot of the time nobody is going to know, but as we know, that's not the test. It's the honesty that we show when nobody's looking is the the example of our ethical standards. There was one in the ACT, Lander and the Council of the Law Society of the ACT, that points out that we have an obligation to be honest and forthright with everybody, whether or not they're our opponents, and not to move beyond legitimate advocacy to try and intimidate or embarrass people.
Yes.
Yeah, that's a big one. I think we're all aware of practitioners who do that, and it's not useful, it's not ethical. We have to be really forthright and put forward our client's case, but we don't need to be belittling.
No, agree. And certainly as a mediator, I'm always alive to that dynamic and trying to ensure that, because saving face is important.
Absolutely.
And you're often dealing with power dynamics,
yeah.
Senior and junior people and states of knowledge, and you've got to really navigate that closely. But let's think about it also from the perspective of other things that juniors and solicitors coming up in this space should be alive to. I mean, have you come across ethical dilemmas in your practice in the negotiation context that you think might be useful to share?
Yes. The big one that comes to mind is that as a junior practitioner, I once had a settlement where we'd reached an agreement. I'd received instructions, we'd accepted the offer, and then there were two respondents in this claim, both entered the wrong figure in the discharge. They put a higher amount than we had agreed to settle, and I had no idea what to do. So I just told the client, I don't know whether we can rely on this, but just sign it and I'll run back and figure out what to do when I've spoken to my supervising partner. And that comes under the category of we can't rely on an obvious error.
Yeah.
Which comes back to my point about junior solicitors being under pressure and in an environment where, well, this would be great for my client. If they had that much money already, I should have got it during the course of negotiations. But they did pick up on the error, and I had to say, yes, that is an error. We're not relying on it. Send us through the corrected discharge.
It's not just similar to inadvertent disclosure kind
Absolutely.
of rules. When you know it's inadvertent, you can't rely on that, and you've got ethical obligations because, let's face it, if you get something you shouldn't, it's going to happen to you once or twice. We've all done it. We've all been there.
Yeah,
so we're relying on that goodwill in the profession, that ethical obligation.
Absolutely, and it is in the solicitor's conduct rules too. That and it's usually drafting errors. It's not usually the amount of the settlement and the discharge, but drafting errors like the discharge, including a term that was specifically not agreed to between the parties and things like that. We can't rely on those. But yes, it's all very well, as I say, away from the pressure of being there in the moment. So
one of the things that I was alive to, similar on a defendant side of the ledger, was say, for example, you had a sense that the employer was going to be restructured. Someone was still currently employed, or you might even think this employer has inverted commas form for changing employment relationships post-injury or post-settlement. You had to be really careful. Obviously, that was obviously factored into your analysis, but you wouldn't state anything going to the to the certainty of employment. You'd stay right away from it.
Yeah.
Would I have been obliged to say there's a restructure if there's only a potential? And I don't know that. I may suspect that, but I don't know that. I factored it into my assessment, but does my ethical obligation say...
That's a bit tricky, isn't it? Because you don't know.
No, I don't know.
Yeah.
And that's what I'm now justifying the approach that I took.
Yeah.
Because
I can't see how you can disclose something if you don't know.
But in the event that there is what happens if, for example, another scenario, there is a restructure, but it's not yet apparent that that person, the plaintiff, may be impacted, but I know about it. I would think that may cross the line.
Yes, I think that
potentially
does.
It would make me uncomfortable.
Yeah, I would disclose that.
Yeah. Even if you may say, fairly speaking, that it may not impact their department. It depends on how, there's some nuance in that.
There's always nuance. It depends on the details, doesn't it? But yes, I think it's one of those things where better to disclose it and then explain why it's probably not going to affect the figures than to not disclose it.
Yeah, that's right. I had one recently where someone said, an older person, there will be a fitness for duty assessment, and it's likely that you won't, and you feel, well, that's credible.
Yeah.
They can make the choices they need to make. And there seems to be, we've sometimes been the victims of our own success in Queensland. It is quite a collegiate profession, and you do see some relatively good examples of how it's done well. Any other ethical dilemmas that you can enlighten us on?
No, really it's those more nuanced ones are the ones that come up every time. The overstating the assessment of
I think
prospects
that's really
of success.
important. I think that's really important, and bottom lines.
And bottom
being
lines.
really clear about that.
Yeah.
And let's face it, you've got to be careful anyway, because what is a inverted commas bottom line is also an evolving concept.
Absolutely.
What is a bottom line now compared with the reality of a court process? And I'm alive to that risk framework as a mediator. That can change.
And all of those things come up pretty much in every negotiation you ever have. There's always some woolliness about the bottom line, the appetite to go to court.
That's right. And as you say, someone's genuine appetite to go to court may need to be tested at some level.
Absolutely, yeah.
It's all very well to say I don't want to go to court, but you might decide next to that offer I do. And so how can you probably,
Yeah, absolutely.
Listen, Kate, I really loved it. As I said, I think that we don't do enough to talk about this.
Absolutely.
I know at an AALA event coming up, I'm addressing this topic. I know it's an area of great interest, and you've done some education in this space as well. So thanks for coming here today and for this important discussion.
Thanks, Damien.
Thank you.